All right, well, according to the MacBook to my left here, it says at 7:30, so we'll go ahead and commence with this meeting. So I'd like to welcome everybody to this meeting of the Village of Skokie Zoning Board of Appeals. The Zoning Board of Appeals is created by the statutes of the state of Illinois and by the ordinances of the Village of Skokie for the purpose of granting proper case relief from the strict terms of our zoning ordinances. The decision of this board to either grant or deny relief will be based upon the evidence presented to it and how that evidence is related to the standards for granting relief. All persons who have an interest in the case, either as a petitioner or as a member of the public, either supporting or opposing the petition, or as an independent witness, will be given a chance to speak on the record and to express his or her points of view. The Zoning Board of Appeals is not a court of law, and therefore we do not follow the strict rules of evidence. However, this meeting will be conducted in such a manner as to hear only competent evidence or statements. Questions as to procedure, interpretation, and of the admissibility of statements or evidence will be ruled upon by Corporation Counsel Tyler Kobilski, and his legal decisions will be binding upon this board. Certain cases require a covenant running with the land. This will be prepared and recorded by the Village of Skokie Legal Department, and this is done at the petitioner's expense. Whether or not a covenant is required is a determination to be made by the Corporation Counsel at the conclusion of each individual case. If a covenant running with the land is required, it cannot or will not be prepared until our court reporter has returned to the Zoning Board of Appeals a transcript of these proceedings. The Village of Skokie will notify each petitioner when the covenant has been prepared and is ready for signature. No building permits can be applied for or issued until the covenant is signed by the petitioner. Should a petition for variation be denied, or should a covenant not be required, the Board of Trustees will authorize a refund of any required fees. Should it be necessary for the petitioner to request a continuance due to lack of preparation, a case continuation fee of 1/2 of the original application fee is due prior to the rehearing date. This request must be made before any testimony begins. All petitioners must receive a vote of the majority of the zoning board present in order to decide any matter under consideration. Our full complement is 9 members. However, tonight's complement is 8 members, making 5 votes necessary to make a determination on a petition. Okay, so tonight we have 4 cases on our agenda. 2018-13Z, 7445 Lowell Avenue. 2018-14Z, 9543 Avers Avenue. 2018-15Z, 4837 Jerome Street, and 2018-16Z, 9456 Keystone Avenue. Quite a full docket for the evening. And in these cases, I'll ask Corporation Counsel, has proper notice been served and notarized?
We'll find out, but I think so.
Oh, how dramatic.
I know.
Okay. All right. The Corporation Counsel has informed me of a few things that we will address prior to the hearing on the particular cases. So we'll address them when the time comes. So with that being said, everybody received in their packet the minutes of our previous meeting from November 7th, which we heard 2 cases, 2018-11Z, 3641 to 3647 Dempster Street, and 2018-12Z, 1071 Skokie Boulevard, and both these cases were approved unanimously. And let's see. So if everybody has had a chance to read the minutes, the chair will entertain a motion for the minutes to be approved.
So moved.
Okay, so moved by Commissioner Gerstner. Do I hear a second?
Second.
Okay, Commissioner Jacobson. All in favor, say aye. Voice vote, please.
Yes.
Aye.
Okay, anybody opposed? No? Okay, thank you. Thank you, Marlene, as always. So we'll go ahead then, and since there's so many people in the audience, I asked, we like to swear everybody in at one time, so if you'd all please rise. Do you affirm that the testimony you are about to give is true and correct to the best of your knowledge or belief? Please answer in the affirmative. Yes. Okay, anybody not answer in the affirmative? No. Okay, thank you. You may be seated. Appreciate that. Okay, So we'll go ahead, and without any further ado, we'll go into our caseload for the evening, since people will be patiently waiting. So our first case is 2018-13Z, 7445 Lowell Avenue. If the petitioners would please come up to the podium. Commissioner Arden is presenting your case for the evening. So Sean, go ahead and take it away. The floor is yours.
I'll just state very briefly that notice is proper and correct in this case.
Okay, good. As I said, we will tell the individuals. Okay, very good. All right, thanks.
Okay.
Sean, please proceed.
Right, apologize in advance. The names will probably be pronounced incorrectly. Shliman and Chamunu Adam request a variation in order to build a 280 square foot detached garage resulting in a 56.9% lot coverage by impermeable surfaces and a 42.7% lot coverage by buildings rather than the 50 and 40% maximums respectively as required by sections 118-78B and 118-1128, the zoning chapter of the Skokie Village Code in an R2 single-family district. I will now read the petitioner's state into the record. 1, there is a limitation on the use of property due to physical, topographical, and geologic features. 2, without a variance, there can be no reasonable use of the property. 3, the request is not based solely on economic reasons. 4, the property owner did not create the necessity for the variance. 5, the request is the minimum variance necessary to allow reasonable use of the property. 6, the request will not be injurious to public health, safety, or welfare. 7, the subject site possesses one or more unique characteristics generally not applicable to similarly situated properties. Forestry, civil engineering, and community development has no comment in this case. Staff recommendation, staff recommends that it be approved based on the following condition. A dry well must be installed per the civil engineering division's requirements.
Okay. All right. Good evening.
Good evening.
May we have your name, sir, and spell it for the record, please?
Yeah, my name is Shleman Adam, Shleamon.
Okay.
Last name Adam, Adam.
Okay, very good, sir.
I live at 7445 Lowell Avenue.
Mm-hmm.
Yeah, that's where I'm planning to have a garage built. The reason is that we are 4 adults in the family. We are all driving. We have 4 cars. And also, you know, we'd like to have one of the cars garaged. At the same time, you know, courtesy to our neighbors that we would like to, you know, because our neighbors have each designed a spot for themselves in front of the street, so we don't want to be a nuisance to, so we decided to build this garage for one of our cars. And also, you know, I'm in an age when I'm about to retire, not to, I mean, you know, that I want to, but ailments, it's causing me so I would be able to travel far from the house.
Okay.
So that's why I'm planning to have, and I asked
That's good.
Tony to,
Would the gentleman that's
something-
next to you, would he like to come up and speak on the record about your case as well?
Well,
He's
I'm
Please.
a friend of his. My name is Anthony Yosef,
Okay,
Anthony,
okay,
Youseph.
okay,
I own A. Anthony's Incorporation. I'm a builder here in Skokie, so I'm also his friend, so I promised that I would build his garage for him, and I would follow all the rules that required by code.
okay. All right, all right, great. So far, so good. Commissioner Arden, would you like to give us your impressions on the case?
Saw the property, there were many other homes with a detached garage. I don't think this would be an issue. This would be great.
Thank you.
Okay, that was all encompassing. Is there anybody in the audience that would like to speak on the record of this case?
Yes.
Yes, sir. Please come on up to the podium.
Introduce yourself.
Okay, yeah,
Good evening.
please tell us your name, sir, and spell it so that we may have it for the
My
record.
name is Anthony Fanady,
Okay,
Fanady,
uh-huh,
and I live next door to the gentleman who wants to build a garage to
Okay.
the north side. The 2 houses are identical. They were built at the same time. And this is my attorney, Peterson, and he's gonna speak for me.
Okay. Mr. Peterson?
Yes, my name's David Peterson,
Okay.
Peterson.
Okay.
I am an attorney, so I feel like I'm appropriate to be speaking for Mr. Fanity.
Okay.
So the property, I've reviewed the proof of the finding of facts, the 7 variables. And although Mr. Arden seemed to find in favor of building on the garage on each one of these considerations, in a closer look, maybe one of the 7 considerations is actually valid. The first one, limitation on the use of the property due to physical, topographical, and geologic features. This has been a home that's been built and been in existence for 59 years. There's been no garage. The 2 lots, Mr. Fanity's lot and the subject property, were one lot at one time. They were split by 2 sister-in-laws, 2 daughter-in-laws. They built the houses, and then there's actually bushes going right down the middle of the property line that were planted. Nobody knows really whose they are because they literally run some on one side, some on the other. So the first consideration does not fall on behalf of finding that a variance should be approved. The second one, the applicant can demonstrate that without a variance there can be no reasonable use of the property. Well, it's been used for 59 years as a single-family residence. Nothing shows that it's been reasonably used more than use for 59 years. So again, that second consideration I don't believe has been met. The third one, the granting of the variance is not based solely on economic reasons. You heard the subject property owner speak, makes sense. So I would give him that one. That makes it 2 to 1. The fourth one, staff feels that the necessity of the variance was not created by the property owner. Well, 59 years the variance was not needed. He just testified that he wants it, that it's his need, no one else's. There's no other basis for it except his desire to have a garage. Over of the 50% and 40% requirements. The next one is the variance requested is the minimum variance necessary to allow reasonable use. That's really not true. There's a shed that is not shown in the drawing. My understanding is the patio is being removed, but the shed is to remain. Why is the shed not being removed? That might even put it under the 50% threshold, and we wouldn't even need to be here today. But it's my understanding that that's not. I could be wrong on that, Mr. Arden. If I am, please let me know. But my understanding was that the sidewalk and the patio was to be removed, but not the shed. So we're going to have a driveway and a shed right next to each other across pretty much the whole back portion of the lot. So that would not fit into the proposed finding of fact. The granting of the variance will not be injurious to the public, health, safety, or welfare. Where is this dry well going to be put? There's no showing of any plans. They said just so I quote it, a dry well must be installed per the Civil Engineering Division's requirements. We haven't seen those yet. It seems like we're putting the cart before the horse with this vote. We don't know where they're going to recommend putting the dry well. And that may seem like it's not a big deal, but if you see where the proposed garage is, just to the north of it is my client's property. It's going up right against it. Where can you put a dry well that water that falls off, comes out of a gutter on that side of the house, or garage, is not going to end up in my client's backyard? Nowhere. I suggest that there's nowhere that a dry well can be built. A dry well is not supposed to be built within 4 feet of property lines. Well, this proposed garage is going to be within the lot line proposed. So where could you put a dry well which would adequately protect my client's backyard from flooding? If we're going to go over the 50% amount and we're going to put it such that the water almost is forced onto my client's property, because the dry well appears to be between the house and the garage, so it'll protect the subject property owner's land, but not my client's land. That seems like a risk on my client's behalf and no benefit for him. So that does not fall on the side of finding a fact that there's no proposed or possible injury to the public. If we knew where the dry well was, maybe we could say that looks okay, but it doesn't. The property subject to the variance request possesses one or more unique characteristics generally not applicable to similarly situated properties. My clients lived, as I said, exact same house, exact same yard, no driveway. No driveway, no garage. So there is nothing different between those two properties. So if you look at the 7 characteristics or considerations, it's really 6-1 against giving the variance. Certainly, if the variance was to be granted with the 57 and 42% requirements, they could be reduced by just requiring that shed to be removed, because that should lower it. But that's not even asked for. I don't know if there's a way to show pictures of where they want to propose the garage in relationship to where my client's patio is. Brian, is this? That's not. Okay, so can I stand up here? Sure. My client has a patio right here. This is where their patio is. It's going to be blocked by their house, their garage. Right up against it. It just doesn't seem to make sense. Why not put it over here? Put it in the middle. There's a lot of variants and variable options that could have been done that would not potentially injure both the use and enjoyment of my clients and the possible harm done by the amount of water that is going to be forced onto their property strictly based on the design and the location of the water that is going to be forced off the roof. We don't know what kind of roof it is. Is it a pitched roof? Is it a flat roof? Because if it's pitched roof, half the water that hits that is going to be forced right out onto my client's property. And that just seems like it's an inappropriate reason to give a variance in this matter. Thank you.
Well heard, counsel. If I may ask staff, you heard Mr. Peterson argue on his client's behalf quite vociferously about the dry well. Do you think you can alleviate some of his concerns about that?
Two points. The first would be the shed. There is no shed shown on the site plan. So if this were to be approved with conditions, the zoning board can make a condition that the shed be removed. The site plan that's been submitted does not show a shed. So this is what's being reviewed. These are the coverages are based on what's on the site plan that's been submitted and on the screen. So there's no shed being proposed on this site plan. So if this were to be approved with or without conditions, there's no shed on the site plan. Any shed that it currently exists would have to be removed. In regards to the dry well location, the Zoning Board of Appeals can also put a condition in regarding the location of the dry well, that it be so many feet away from a side lot line. Staff would recommend that it not be placed in between the detached garage and the north property line, that it would be in the rear of the garage, in between the garage and the house, or south of the garage. But there's no question a condition can be placed that if the vote is to recommend approval with a condition a dry well be installed per our civil engineering division standards it'll be designed to take the 280 square foot garage at a certain rainfall amount. That there can be a condition in regards to the placement of the dry well, that it be at least 5 feet from a side lot line and placed south of the garage, or something similar to that.
Okay. Now, that's, as we're looking at the site plan that's up here on the screen as well, from what I kind of discerned from Mr. Peterson's argument on behalf of his client is the actual placement of the garage, if I'm not mistaken, is that it will be very close and obstruct, if you will, the where his client's patio and backyard is?
Well, the code allows for a detached garage to be constructed with a 3-foot setback off the side lot line and 5 feet off the alley, and that's what's being proposed.
Okay.
Now, whether the petitioner would want to amend that and say they have no problem moving it to the other side, so that's not my call to make. As proposed on the site plan, 3-foot setback from the north side lot line is allowed by right, and a 5-foot setback off the alley is allowed by right.
Okay, so what is shown up there is allowed by right?
Is in regards to the placement of the garage, yes.
Okay, all right. So in that case, that's really not even an issue as far as that's concerned. So, Commissioner Perlin, did
Well, I was
you?
just going to say that indirectly, the placement could be, because it could be a condition of granting the exemption for the permeable surface, or at least we could maybe have a discussion about the placement.
Mhm.
And the location of the dry well could be a condition as well.
Oh, absolutely.
And the shed removal, so maybe the petitioner could answer some questions at this point.
I could answer on his behalf.
Sure.
Sure.
Yeah, Mr. Yosef, yeah.
The shed will be removed, obviously. I mean, it's not
Okay.
there, it's not gonna be there. Far as, the reason we're on that side, because there's a electrical pole right there, so we can't, that's the only place we could put the garage, okay? And, garages, we do install gutters on them, you know? So you don't have to worry about rainfall going to your neighbor. It's gonna go towards the alley, and it's gonna have a dry well. So you don't have to worry about stuff like that. I mean, we do use gutters, okay?
Yeah, if approved with the dry well condition, gutters will have to be installed and they will have to be connected to the dry well. And again, the placement and location can be a condition of the variation.
Right. Yeah, the positioning of the dry well itself. Yeah, Commissioner Gersner?
So we've had dry wells put in before
Okay.
on buildings, and they've worked fine. If our engineering department says that it can take, is it 200 square feet, you said?
Well, it's based and designed on the size of the garage for I believe it's a 2-year rainfall. The design is based on the size of the garage.
We've never had a problem with the dry wells. The dry wells work, in fact, they work better than when there's nothing there, even if you didn't build a garage.
Exactly.
They will pull water away quickly. We had a case earlier this year, and the dry well was working fine on it. It was pulling more water away than it had been before it was put in. So I see no problem with that.
Okay.
I have a question just for Brian,
Yeah,
really quick.
Commissioner Arden, sure,
So
please.
is there no place on the property that the dry well could go that would not interfere with their neighbor? Because that's what I recall we were just told 5 minutes ago or so. There are places it could go without interfering with their neighbor, correct?
The dry well can be placed south of the detached garage. It'll be the gutters coming down.
Okay, and it wouldn't interfere with their neighbor, correct?
If-
No.
Okay, thank you.
It'd have to be a massive flooding rain, to have any impact if it's south of the garage, which I'm not a licensed professional civil engineer, but if the dry well is located south of the detached garage and there's a garage in between, the petitioner's subject rear yard would have to completely flood to then flow over to both neighbors' yards.
Okay,
The
thank you
impact
for
might-
clarifying.
Impact might be more to the south neighbor.
And remember, the dry well is underground. So there's really no impact.
Can I briefly address that? Because I think,
Go ahead, Mr. Peterson.
thank you. My understanding that there was never any solid comment that the dry well was going to be connected. I understood that there were going to be gutters on the garage. I understood that. But that didn't mean that, even the way he spoke, they were going to be emptying out into the alleyway, is what he said. He did not say that they were going to be connected to the dry well, just that there was going to be a dry well. And quite often, dry wells can have a groove, quite often filled in with like a little dirt or a gravel incline that the water will run down into the dry well. So there's no specific showing that the dry well will be connected by gutter piping all the way down to the underground. We're not saying that the dry well itself would get in the way of my client. The dry well's underground, dug 4 to 10 feet down. There's not a question that the dry well would cause the problem. It's the fact even the way the builder talked about, that the water from the gutter would be going out into the alley. He didn't say that, I didn't understand him to say that the gutters would be connected by pipe to the dry well. That's a different statement.
Yes, the gutters would be required to be connected to
Okay.
the dry well with no gutter discharge.
I don't think he was aware of that until right now.
Yeah.
So that's why.
No. The back gutters usually, okay.
Yeah, please,
The back-
please,
the
Mr.
back-
Yosef, please stand up to the podium, please.
Normally, the back gutters go to the dry well. The front gutters go to the alley. That's how normally we do it, okay? But we could do whatever the engineer requires. Okay, whatever Mr. Sabine says, that's what we'll do. If he wants them all going to the dry well, no problem.
Well, for the garage, it would be required,
Okay, that's
the garage would have to be, they would be required
Yeah,
that
no problem.
they would have to be connected directly to the dry well, and I'm assuming most likely this would be south of the detached garage,
Okay.
to be roughly in the center of the lot.
Right, so south of the detached
Yes.
garage,
No
as we
problem.
see right now. Okay.
Thank you.
Sir, is there any other, it sounds like, Mr. Peterson, if I may, that your client's concerns were basically that his property would have some flooding issues because of this?
Well,
Or-
the view.
Please, at the podium, please.
I apologize.
That's all right. We just want to make sure we have, there's no
No,
misunderstandings.
I think my client's concerns are the view that is going to be, by building a oversized impermeable use of the property, is going to be blocking the view from his porch, which is right there, or his patio, which is right there, along with the concerns of water. So it's twofold. It's not onefold. It's both.
Well, as staff has said, theoretically, by right, he can actually build that garage there.
I understand that, but that doesn't mean you should be allowed to build an oversized property above the 40% and above the 50%. They're asking for a variance. They're asking for an exception to the law. So the burden is on them to explain why they should be able to get an exception to the law. And is it injurious to the public in any way? There are 7 factors. When you look at 7 factors, it just doesn't seem that the right result, in any way you slice it, is the allowing of the variance with the garage situated up against the corner of the lot. The builder talked about there's a telephone pole or electric pole. That's on the other side of the alley. So it's got nothing to do with anything.
No.
Yeah.
The electric pole is right on his side.
Yeah, I see it.
Yeah, we
Along
see-
with the garage that's on the other side of this guy's property, so.
And for the record, the current impermeable surfaces on site, the total coverage with the house, sidewalk, patio currently exists is approximately 2,636 square feet roughly. With the removal of the patio and the removal of the rear walk past the garage entrance, the impermeable surface will drop to 2,448. So there will be a reduction almost 180, 190 square feet from currently to proposed.
Right.
They're basically taking out a large patio and sidewalk to put in a garage that's smaller than the current patio, and the garage will have gutters, downspouts connected to a dry well to compensate for the stormwater hitting the garage.
So, in other words, if I may say, what you're saying is what is being proposed here from a flooding control standpoint is better than what exists currently on the petitioner's property.
In my opinion, yes.
Oh, yeah. The figures bear it out. I'm
Yeah,
looking at it.
I'll put the zoning worksheet on the
Okay.
screen.
Commissioner Perlin?
So, for clarification for the record, is this a normal lot size?
No,
This- no,
it's substandard.
It's a
So
substandard lot.
This is a substandard lot size.
That's correct.
And so that's, I think, one of the most relevant considerations here, is that,
But look up there, and you'll see the impermeable area right now and the impermeable area afterwards. It actually gets better with the
Right.
garage.
right, well, and my point is, because it is a substandard lot size, my strong feeling is it clearly meets the first, and in this case, the most important requirement, that it's a limitation of use due to physical, topographical, or geologic features. In this
Right.
case, because it is a substandard lot, and we're talking about sort of the smallest garage, which is a one-car garage.
So in building the garage and taking out all the concrete, and the shed, we're actually improving,
The actual square foot.
right, the water retention will be less with this, and especially with the dry well, than if we did nothing.
And I would say the location of the garage is limited also by the feature of the
Correct. By
property, in this
ti-
case,
the-
utility pole.
By the area, absolutely.
Okay. All right, any other questions, comments? Is there anything, there is something that I did note in the forestry comments. They mentioned that there's a room for a new tree in the parkway adjacent to the subject site, and it's a $150 fee. Would that be acceptable if we made that a condition as well?
Yes.
It would, okay.
Yeah, for new construction addition garages, forestry is notified, and if there is room in the parkway, then a permit fee, the $150 permit fee would be imposed to the owner applicant for them to pay us, and then we would install the tree.
Does that kind of fall under the heading of all other codes and ordinances? will be-
Correct.
Okay, so that's basically a standard point. Okay. All right. Yes. Okay, anything else anybody would like to close up with on this? Or is there any other questions or comments from the audience in regards to this case? Besides what we've heard from the petitioner and from Council Peterson? No? Mr. Yosef, you heard about the conditions that were mentioned on here. The dry well must be installed per the civil engineering
Of course.
division's requirement, and it will be installed to the south of the garage?
Yeah, of course. I mean,
Okay.
we cannot come up with any plans till we get approved here first.
Oh, yeah, of course, certainly.
Okay, so
But,
that's why-
but what we're saying is, as a condition for
Oh, yeah,
the
yeah, of
approval,
course.
for you to move forward, we're
Yes.
asking if you agree with these conditions
Yes,
that
of course.
we will impose upon you.
Yeah.
Okay, and that, in this shed that we don't seem to find
That's,
in our
It's not-
documentation
that's.
will be removed. So, no shed on the property, in other
No,
words?
of course not. I
Okay.
mean, the garage will be inspected, everything will
Right.
be inspected. Brian goes on inspection, and this,
There's
you know, Steve, they will
George,
notice
Steve.
everything,
That's it?
so.
That's it.
Oh, okay, all right,
Here's the whole property
okay,
from the back.
okay.
So what is the size of the shade?
Right, okay. We're looking at a Google Maps, and we do see the shed on there, so,
Yeah, it's right here.
okay. It's kind of in the
It's a tiny-
southeast corner of the
Yeah.
property? Okay, all right, so that'll be removed then. All right, any other questions or comments? No? Will this meet with your,
We'll let you vote, Mr. Chairman.
okay, all right, thank you. All right, if there's no other questions or comments, then the chair will entertain a motion.
Mr. Chairman, I propose the following findings of fact and the granting of a variance to the petitioner as follows: that Shulman and Shamanu Adam are the owners of the lot described in case number 2018-13Z for the property located at 7445 Lowell Avenue, Skokie, Cook County, Illinois. That said lot is a plotted lot of record and is abutted by single-family dwellings in the north and south. That a determination is made in which the petitioner's request is consistent with the majority of the findings of fact as stated in the Village of Skokie zoning chapter. I therefore propose that the following variances be granted to the petitioner for giving failure to comply with the requirements of the zoning ordinance of the Village of Skokie as amended to impermeable surface. The petitioner be granted the variance to build a 280-square-foot detached garage resulting in a 56.9% lot coverage by impermeable surfaces and a 42.7% lot coverage by buildings rather than the 50 and 40% maximums respectively as required by sections 118-78B and 118, I think I have those, yep, 118-1128 of the zoning chapter of the Skokie Village Code in an R2 single-family district. To all other codes and ordinances, the Village of Skokie shall be fully and strictly complied with.
Right. Did you add the conditions on there, Sean?
No, well, didn't we discuss what the conditions were?
They need to be made part of the
Yeah.
motion.
I'll read them into the motion.
I don't have them. Did you want to state them?
Okay, Corporation Counsel, if we may.
The dry well to south.
Okay.
Just adding the condition that a dry well must be installed per the Civil Engineering Division's requirements,
And installed to the south of the garage,
if that's what you want, and installed to the south of the garage,
and that the existing shed be removed from the property.
and that the shed be removed.
Okay, there you go. Okay, all right, so we have a motion with the conditions of the dry well, dry well positioning and the shed being removed. Do we hear a second?
I'll second, Mr.
All right,
Chairman.
Commissioner Salvi will second. So the chair will go ahead and call the roll. Commissioner Salvi?
Aye.
Commissioner Arden?
Yes.
Commissioner Jacobson?
Aye.
Commissioner Gerstner?
Aye.
Commissioner Shaw?
Yes.
Commissioner Beverly?
Aye.
Commissioner Perlin?
Yes.
And the chair will vote aye. So in the matter of case number 2018-13Z, the motion to approve with conditions has been passed unanimously. What does the petitioner need to know from here on out, Corporation Counsel?
We will work on preparing the covenant, running with the land. It should be ready for the property owner's signature in about 2 to 3 weeks, and then you'll get the building permit.
Okay,
Thank you.
Okay.
thank you so much.
Thank you for your time.
Yep, yeah, you're very welcome.
Thank you, Brian.
All right. Okay. Well, be that as it may. Okay. Okay, we'll go ahead and we'll move forward then with our next case, 2018-14Z, 9543 Avers Avenue. And I believe Corporation Counsel had a question.
Yeah.
So if, first of all, if the petitioner would step up to the podium for this case? Good evening, sir.
Good evening.
Can we have your name and spell it for the record, please?
It's Samuel Pavlovchik. That's SamuelPavlovcik.
Okay, thank you, miss. Thank you, sir. I believe Corporation Counsel has a question for you.
Just a couple of questions for you. Were you the one responsible for sending out notice on this case?
Yes.
You were, okay. So on the very last page, I know it's kind of far away, but there are 3 addresses that don't have the mail date next to them. Do you know if they were also mailed on the 19th of November like the rest of them?
Yes, they were.
They were, okay. All right, the notice is proper and correct.
All right, very good. And I know that Commissioner Jacobson is presenting this case. So Elaine, the floor is yours. Go ahead and take it away.
Okay. Case number 2018-13Z, 14Z, 9543 Avers Avenue. Elsa and Stefan Ettridge, on behalf of Samuel Pavlovic, request a variation in order to construct an addition that increases the number of bedrooms on site, resulting in the continuation of 1 motor vehicle off-street parking space rather than the 2 minimum as required by sections 118-201-2 and 118-218-1 of the zoning chapter of the Skokie Village Code in an R1 single-family district. Okay? And I'll read the petitioner's statement made by Pavlik Architecture. A zoning variation is requested to allow for the existing single-family residence to be allowed to maintain the existing 1 off-street parking space, a proposed 2-story addition and interior remodel, building permit approved, currently pending, to the existing residence creates a total of 4 bedrooms, which adds a total of 2 bedrooms to the existing 2-bedroom single-family residence. Due to the existing setbacks of the property, a widened parking pad to allow for 2 vehicles is not possible without causing encroachment upon the front yard setback, Sincerely, Samuel Pavlik. Okay,
Okay.
all right.
Let's see. If you would, Elaine, in the staff report, there's a comment by the Forestry Division
Yes.
that I think would be important to read in this case.
Yes, I'm looking for, wait a minute, there are so many papers.
Here, that's okay. Here, Elaine. Just read the Forestry
okay.
Division comment and then hand it back to me.
Staff recommends that the petitioner's request to construct an addition that increases the number of bedrooms on site, resulting in the continuation of one motor vehicle off-street parking space.
Well,
Yeah,
and then
okay, yeah,
read
be
that.
granted, okay. The Forestry Division recommends that the petitioner's request be approved and maintain the existing driveway width. If the existing driveway is widened, a parkway tree would most likely need to be removed. During construction, tree protection will be required for all parkway trees adjacent to the subject site.
Okay, great.
Okay. All right.
Okay, great. Good evening.
Good evening.
Well, you've told us your name, you've spelled it for the record, so could you please go ahead and tell us why we're here tonight?
Sure. So I'm a licensed architect. I'm here on behalf of homeowners Stephen and Elsa Attridge. They're looking to do a rear addition onto their home, the first floor with a living space, the second floor with a new master bedroom. They're also trying to do an interior remodel, which splits one large bedroom that's about 25 feet long by 12 feet wide into two bedrooms. So they have one 3-year-old daughter and another daughter on the way. Right now, the zoning code requires that with any additional bedrooms, that 2 spaces be provided. However, due to the existing conditions of the lot, we're unable to get 2 parking spaces onto the lot. Also, zoning code does not allow for tandem parking in which 2 cars would be parked in a row. So really our only option right now is to maintain the 1 current off-street parking spot, not including the single attached garage.
Okay. All right, great, thank you very much. Yeah, Commissioner Jacobson, would you like to give us
Yes.
your impressions on the case, please?
Yes, I went there and I looked at the property. There is a very long driveway. Are they planning on widening, doing anything with that driveway, changing it in any way?
No, they're not planning on
Okay.
changing it.
Okay.
It looked, there could be, like, with the garage, there could be 2 cars, and I noticed there was ample parking space on the street. There was no problem with that.
Mhm.
Yeah.
Okay, that's it?
Yeah.
Okay. Any other questions for the builder, for the architect here on this case? No? Anybody in the audience wish to say something about the case on Neighbors? No? Would you like to wrap up with any final impressions? I think we pretty much said it all in a nutshell.
Just thank you for your time.
All right, great. All right, if there's no other questions or comments, then the chair will go ahead and entertain a motion.
Okay. Motion, Mr. Chairman, I propose the following findings of fact in the granting of a variation to the petitioner as follows. Petitioner Elsa and Stephen Attridge are the owners of the lot described in case number 2018-14Z for the property located at 9543 Avers Avenue, Skokie, Cook County, Illinois. That said lot is a platted lot of record and is abutted by single-family dwelling building sites, etc., on the north and south of the building. That a determination is made that the property in question cannot yield a reasonable return if permitted to be used only under the conditions allowed by the regulations in that zoning district. The plight of the owner was not created by the owner and is due to unique circumstances. The variation, if granted, will not alter the essential character of the locality. I therefore propose that a variance be granted to the petitioners for giving failure to comply with the requirements of the zoning ordinance of the Village of Skokie as amended as to off-street parking and loading requirements. That the petitioners be granted the variation in order to construct an addition that increases the number of bedrooms on site, resulting in the continuation of one motor vehicle off-street parking space rather than the two minimum as required by section 118-2012 and 118-2181 of the zoning chapter of the Skokie Village Code in an R1 single-family district. That the petitioners be granted that all other codes and ordinances of the Village of Skokie shall be fully and strictly complied with.
All right, very good. We have a motion to grant without conditions. Do I hear a second?
Second.
Okay, all right. All right, Commissioner Shaw has the second. Okay, we'll give it to him this time. In that case, the chair will go ahead and call the roll. Let's see, Commissioner Perlin,
Yes.
Commissioner Beverly,
Aye.
Commissioner Shaw,
Yes.
Commissioner Gersner,
Aye.
Commissioner Jacobson,
Aye.
Commissioner Arden.
Yes.
Commissioner Solovey.
Aye.
And the chair will vote aye. So in the case of 9543 Avers Avenue, the petition has been approved unanimously. Congratulations. Corporation Counsel, what does petitioner need to know from here?
We'll
Need to
work-
know from here on out.
We'll work on preparing the covenant, running with the land as well. Should be ready in about 2 or 3 weeks for the property owner's signature.
Okay.
All right.
Thank you.
Good luck with your project.
Thank you.
Okay. All right. Now we'll go ahead and move right along with our next case, which is 4837 Jerome Street, 2018-15Z. If the petitioners would like to come up to the podium. And before I know Commissioner Gersner is presenting this case, but before we go into that, Corporation Counsel had a question for the petitioner.
Sure.
Okay. All right, hold on a second. Let's wait for him to approach the podium.
Just to start.
Hi, good evening.
Good evening.
May we have your name and spell it for the record, sir?
Sure. Pavel Matia, Pawelmatyja.
Okay. Yes, sir, please.
Yeah, I'm Salil, S-A-L-I-L,
Okay.
last name K-A-M-A-T.
Okay, very good. Corporation Counsel has a question for you, gentlemen.
Sure, actually, I just have a question for you, Salil. I just want to make sure, because the notary here indicates on the 14th of November that you mailed something on the 15th of November. So on the 15th of November, did you send out all the mail for the
Yes.
notice? You did?
Yes.
Okay.
Uh-huh.
For this entire sheet of all the property owners? All right. Then the notice is proper and correct.
Okay, very good. All right, thank you, sir. That being said, now Commissioner Gersner can move forward with presenting the case.
Okay, thank you.
Thank you.
So is Sali?
Salil is the owner.
Salil?
Yep.
Okay, and Sarita?
Yes, that's the owner's wife.
Okay, Kamat? On behalf of Powell Mejia?
Yes, I think it's been reversed. I'm the licensed architect, and I'm representing the owners.
Okay. And who's Arturo Delgado?
That's my partner. I wasn't sure if I was going to be able to attend today, so I added him to the list.
It's fine? Okay. Request a variation in order to construct an addition and maintain a detached garage resulting in a 3.14-foot side yard rather than the 4-foot minimum as required by section 118-1126A of the zoning chapter of the Skokie Village Code in an R2 single-family district. We have petitioner statement. You want everything read on this petitioner statement? There is 2 full pages.
Do you feel up to it? Or we can say, I mean, the packet is a matter of record, so it's completely up to you. If you feel up to it, then I'll get you an extra bottle of water if you so desire.
Well, let's ask the petitioner. Do you want the entire petitioner statement read into the record, or can we just amend it and say it's available in the packet?
I would say let's amend it, and I do have a short summary that kind of touches upon all these.
That's great. I like the way you think.
No, under normal circumstances, if it's not lengthy, we read it during the course of the meeting. But for anybody out there or anybody in TV land, you can always research the packet online. So-
Correct.
So it's always available and it's already in the record. We just do it as a matter of convenience for everybody.
Yeah, well, there's a copy on file if anybody does wish to read or review the statement. We have a copy.
Awesome. Great. Thank you so much. Okay.
Okay. So
Well,
that
that
was the
saved a-
petitioner statement.
That saved us a few minutes.
Okay.
And a hoarse throat too, I think
Oh,
I
yeah.
might add, huh? You had this already? This document?
I'm getting to that.
Okay.
It was here.
I think
Where
it's in
did it
the-
go?
It was in the other part.
In the first part?
Yeah.
I saw it at the beginning.
There you
Here
go.
it is.
There you go.
Okay.
Okay.
So this is a letter from Salil and Sarita Kamat, 4837 Jerome, Skokie, Illinois, 60077, to the Zoning Board of Appeals, to whom it may concern. We, Salil and Sarita Kamat, are hereby authorized Powell,
Yes.
Mejia, we'll just read your name in because you're the only one here, to represent us in front of the Skokie Zoning Board of Appeals in the matter of the side yard zoning variance due to the proposed rear addition of our house. And it's signed by both petitioners.
Okay.
Okay? And do we have anything here that needs to be? So the forestry department, during construction, tree protection will be required for all trees on the site in the adjacent parkway.
Yes, we have received that notice.
Okay. Also, the detached garage can never be attached to the house.
Understood.
Okay.
Okay. Let me just.
Okay, and the last thing I want to read in is the 3.14-foot setback shall apply only to existing detached garage. And if and when the existing detached garage is rebuilt for any reason, new garage must conform to all zoning regulations. Okay?
Absolutely. Yep.
Okay.
That's good for me.
If that's good for you, that's good for me. Okay. All right, we'll go ahead and moving forward with the petitioner's testimony. All right, good. Yeah, good evening, Mr. Mattia. Please go ahead and tell us why we're here tonight.
Absolutely.
Okay.
So the variance we are requesting is to allow a lesser than code required side setback for an existing garage so that it can remain in its current location. Zoning regulations have different setback requirements for an accessory structure when it is located wholly within the rear yard and when it's not. When the garage was built, it was located behind the principal structure, and the required minimum setback was 3 feet. It was built to meet this standard. So fast forward to today, and the owners would like to add a 2-bedroom addition to their current 2-bedroom house. The owners have lived at this location for 16 years and plan to spend many more years enjoying all that the community has to offer. Due to the size of the family, they would like to increase the amount of living area. Currently, the house only has 2 bedrooms, which is very modest by today's standards. They would like to build an addition to add 2 additional bedrooms to the house. The only practical location for this addition is towards the rear of the existing house. The addition itself will meet all zoning requirements. However, the back wall of the addition, which will become the new rear yard line, will now be located behind the front of the garage. The zoning states that in this situation, an accessory structure must meet the same side setback requirements as the principal building, and in our case, that would be 4 feet. Due to the fact that the garage is existing and is in good shape, we seek this variance so that the owner can continue to utilize the existing garage while also being able to build the proposed addition. In my opinion, granting of this variation will have very little impact as the garage has already been part of the neighborhood for some time. Requiring the owner to modify its location on site can bring a lot of hardship with no discernible benefit to the community. Thank you.
Okay. Ding. As if it was
Time's
on
up.
cue. As if on cue. Amazing. Great. Thank you very much, sir. Commissioner Gerstner, would you like to give us your impressions on this case, please?
Yes, I probably frightened the occupants of the home on Thanksgiving Day when I went over to take a look at it, and they were watching me take pictures out the window. Was that you? You're probably wondering, what's this guy doing getting out of a white SUV taking pictures of my house? You got a lot of cars in that driveway, you know that? I took a look at it. There's a lot of land around that house. Nice neighborhood. I see no problem with putting the addition. It's going on the rear, correct?
That's correct. That
Yeah.
is the solid hatch on the.
Yeah. Looked around, took some pictures. There's no parking problems anywhere on that block. Your family expanding, is that what's going on, that you're putting the extra bedrooms in?
Yeah. Sorry to make it go all the way up to the podium from where you were sitting there, but if you would.
We have 2 grown kids now, so they need their room.
Okay, okay. That's why you got all the cars.
Good thing we're not talking about the off-street parking then.
That's
Isn't
right.
isn't a question here.
That's right.
That's good.
No, it's one of those classic homes, and I think the addition will look fine on it, so that's all I've got.
Okay. Is there anybody else in the audience that would like, that would care to speak about the 4837 Jerome Street case? No? Okay. I just see extra people sitting in the audience. I want to make sure that everybody's voice and opinion is heard. Anybody else have any questions for the petitioner or comments? No? Pardon me? Okay, all right. A stray comment that won't be on the record, that's okay. I too live in the neighborhood. I live about a block away from you folks. And I know the house very well. I know you got plenty of property in the back for it, so I think whatever you wish to do. I know since you've moved in there, you've upgraded that property substantially, so thank you very much for doing that.
It's very nice.
It is, I love my neighborhood. I got nice neighbors, you know, it's all good. Even though I wasn't served notice because I live far enough away, so it's okay.
I still thought they were going to call the police on me.
Okay, if there's no other comments or questions, then the chair will entertain a motion.
Hold on. Okay. Never mind.
Oh, okay.
Okay,
All right.
I was
Well,
just
sorry.
taking a look at the lot lines.
Yeah. No worries.
Okay.
It's all good.
Mr. Chairman, I propose the following in the granting of a variance to the petitioner as follows, that Salik and Sarita Kamat are owners of the lot described in case number 2018-15Z for the property located at 4837 Jerome Street, Skokie, Cook County, Illinois. That said lot is a plotted lot of record, is abutted by single-family dwellings on the east and west. That a determination has been made in which the petitioner's request is consistent with a majority of the findings of fact as stated in the Village of Skokie zoning chapter. I therefore propose that a variance be granted to the petitioner for giving failure to comply with the requirement of the zoning ordinance of the Village of Skokie as amended as to side yard requirements. That the petitioner be granted the variance in order to construct an addition and maintain a detached garage resulting in a 3.14-foot side yard rather than the 4-foot minimum as required by Section 118-1126A of the zoning chapter of the Skokie Village Code in an R2 single-family district, that all other codes and ordinances of the Village of Skokie shall be fully and strictly complied with.
If I may, Commissioner Gersner, can you read the two conditions that were, see this recommendation, and then the two conditions? Is in the staff report.
The 3.1-foot setback shall only apply to the existing detached garage. If and when the existing detached garage is rebuilt for any reason, the new garage must conform to all zoning regulations, and the detached garage can never be attached to the house.
I
Okay.
think it's 3.14. Did you say 3.1?
3.14.
Okay.
Yeah.
Okay, so we have a motion to approve with the two conditions. Do I hear a second?
I second.
All right, Commissioner Jacobson seconds. Okay. And the chair will go ahead and call the roll. Commissioner Solovey?
Aye.
Commissioner Ard?
Yes.
Commissioner Jacobson?
Yes.
Commissioner Gersner?
Aye.
Commissioner Shaw?
Yes.
Commissioner Beverly?
Yes.
Commissioner Perlin?
Yes.
And the chair will vote aye. Okay, so in the case of 2018-15Z, 4837 Jerome Street, the motion to approve has been passed. The motion to approve with conditions has been passed unanimously. So what does the petitioner need to know from here on out, Corporation Counsel?
We will prepare the covenant, should be ready in about 2 to 3 weeks. We'll give you a call, and then the property owners will be required to sign it.
Sounds good. Appreciate your time. Thank you.
Okay, yeah,
Thank you.
good luck with
Good
your
luck.
project. Okay, very good.
I
All
won't
right.
come take any more pictures, I promise.
Okay. All right, good luck. Okay. Okay, all right, so we have finally come to the last case for this evening. 2018-16Z, 9456 Keystone Avenue. And, let's see, and Commissioner Perlin is presenting this case tonight. So if the petitioner please move to the podium. Corporation Counsel, there's no questions as far as,
There are no questions. Notice is proper and correct.
all right, good, thank you very much. So as a petitioner who's come up to the podium, Commissioner Perlin, you can go ahead and present the case. The floor is yours.
This is case number 2018-16Z, property located at 9456 Keystone Avenue. Adnan Memon
Yes. That's me.
requests a variation in order to build a second-floor addition, resulting in a continuation of the existing 4.44-foot south side yard rather than the 6-foot minimum as required by Section 118-111, parentheses 6A, of the zoning chapter of the Skokie Village Code in R1 single-family district. So that's the introduction of the case. I'm going to read some things into the record. First, I'm going to read a statement by the petitioner, which is titled Letter of Intent in Support of Request for Variance, 9456 Keystone Avenue, Skokie. This letter of intent is in support of my request for a variance, and by the way, I may paraphrase some things reading this into the record since this is already a part of the record. For a side yard setback requirement for an existing non-conforming lot The intention is to add a second story to the existing single-family residence and add a two-car garage in the backyard. As such, based on the current code, the setback side yard requirement for my particular lot of record is 6 feet. The existing house, as it stands, has a minimum distance of 4.44 feet from the property line to the south. I'm requesting a variance to keep the existing side yard with respect to the second-story addition. The purpose of remodeling the house is to allow for our growing family to live comfortably in Skokie, and without the second story, this would not be possible. The house is currently vacant, and in order for us to be able to use it, will require more space. We do not wish to create a burden or hazard on our neighbors, so an existing shed between the houses on the south side, which is closer to the property line, has been removed. The entire house will have fire sprinklers throughout. We also would not build any closer than the original footprint. We also considered that the proposed style and structure of the house will be in step with the existing neighborhood, and the proposed project would be an improvement to the neighborhood and result in increased property values for the adjoining houses. Okay, and then I'm going to read some other things into the record once I find them. Here we are. Okay, this is from the fire department. The fire department has no objections, but due to the size of the addition, they'd like the following items to be installed. There are 4 items. Number 1, a fire alarm system. Number 2, residential fire sprinkler. Number 3, an outside weatherproof horn strobe mounted near the front door, which activates on water flow only. And number 4, carbon monoxide detectors. The forestry department states as follows: a tree survey will be required as part of the building permit process. The supplied survey was missing a 7-inch dogwood in the front yard near the southeast corner of the house, a 20-inch evergreen yew in the backyard near the rear lot line, and a 10-inch pear tree in front of the neighbor's portion of the vacated street that needs to be protected. During construction, tree protection will be required for all trees on site or in the adjacent parkway. I'm going to read some portions of the Community Development Department's report. They simply note the building was constructed with a permit in 1954. The original site plan on microfilm shows a proposed 5.5 yard south side yard. However, when the building was built, somehow it was built with a 4.4 foot south side yard. It appears the building was constructed 1 foot closer to the lot line than was proposed on the site plan. I'll also note that the petitioner should be aware that the Civil Engineering Division would allow a permeable paver driveway to be located in the vacated portion of Foster Street as long as water can properly drain per engineering standards. No buildings can be constructed inside this easement. So this concludes the initial presentation.
All right, thank you. Thank you, Commissioner Perlin. I appreciate that. Always good to know where the cutoff point is. Good evening, gentlemen.
Good evening.
Could you please tell us your names and whoever happens to be testifying up at the podium tonight, and then spell them so we may have it for the record?
My name is Adnan Memon, and
Okay.
I'm the owner of the property of the Keystone.
Okay.
And he's my architect. His name is Carlos, so he will represent for everything.
Oh, okay.
Yeah.
I know it's
Good
just
evening,
like,
sir.
Good afternoon, or good evening, yes.
Yeah.
I would just like to make a correction for the record. I
Okay.
am not a licensed architect, I'm just an architectural, I'm just a designer.
Oh,
So,
okay,
mhm.
all right. So are you representing Mr. Maman here?
Yes, that is correct.
Okay, so everything that you agreed to, that we state here tonight, I mean, obviously, he's right behind you, but everything that you say is agreeable onto his behalf?
Yes.
Okay, very good. All right, well, thank you very much.
Thank you very much.
So again, may we have your name and spell it so we have it for the record?
My name is Carlos Sorella,
Okay.
spelled C-A-R-L-O-S.
Uh-huh. Hmm?
Sorella is spelled Z as in zebra, O-R-R-I-L-L-A.
All right, Carl Cirilla. Okay, very good. And you're the interior designer, is it?
Yes, you can.
Designer, okay.
Yes, this is just the designer.
Okay, all right.
I want to ask him about the differences.
Yeah, you can go, you can make that the lead-off question.
Okay.
So how's that? Okay. All right, Carlos, you want to go ahead and tell us why we're here tonight, please?
Sure thing.
Okay.
So this currently is it's a vacant home. It is in a lot of disrepair. The owner wishes to be able to use this property again, and in order for him to be able to use it, he requires more space in his house. The house as it stands has fairly small bedrooms, only has one bathroom, one full bathroom. So the proposal is to increase the size by adding a second floor. Of course, in order for us to be able to use the footprint of the building properly, then we'd need to be able to just build directly upon it. In our contact with a contractor that Mr. Memon has communicated with, there really seems like there's no way for us to just simply push back 1.5 feet in that second floor without really creating a lot of structural kind of having to essentially rebuild the house from scratch in order for that to happen. So for that reason, we're hoping to go into the second level. As part of the improvement in general of the property, then we're also proposing, and this is not part of the variance request, but we're proposing to add a two-car garage, and we've also spoken with Mr. Bryan here. He's let us know that engineering will require us to also have a dry well to direct the flow of the water from that garage over into the main street.
That's it?
I think that's it.
You're not going to be like Commissioner Perlin and say, this ends my presentation? I'm sorry, I'm just kidding you.
It's been a long day.
Yeah, I know. This is our fourth case for the evening. We don't get this very often,
No,
so.
not at all.
We all have a tendency to get slap happy towards the end. Commissioner Gerstner, did you have a question?
I had a question.
Yeah.
I was just looking at the application, and it gives the address of the property, and then it gives an address in Morton Grove. Is that where you're currently living?
Yes, I live in the Modern Grove, and then once we done this property, I'll move from the
You'll
Modern
move
Grove to
over.
the
Okay.
Skokie.
There you go.
Just needed that clarification. Thank you.
Right. Okay, that being said, Commissioner Perlin, would you like to go ahead and give us your impressions on this case, please?
Well, yes, on or about November 24th, I visited the property, and there are other buildings, other residences on the street that have second stories. Some are just single stories, but some have second stories. You can see how it's built close to the south property lot line, but it wouldn't be feasible to really increase the living space and add a second story and somehow indent that second story to allow for the extra, approximately 1 3/4 feet. Personally, I don't see any objection to this. I'd like Brian maybe to elaborate a little bit about requirements related to the garage, which, as I understand, doesn't require a variance to be built. But we had discussed this, and so maybe you could explain what we were talking about before.
I'm not sure exactly what the question is.
Okay, I'm not sure what the question is either. I was
Yeah.
hoping you would. But let me rephrase that then. In terms of the driveway, there is an existing driveway. The garage is going to be new. The garage actually is going to be located opposite the south lot line.
There's currently no driveway on site.
Okay.
The new proposed driveway would be north of the house.
Right?
And due to the size of the garage and the driveway, a dry well would be required be required by code to be installed due to the size of the garage and driveway. So that's a requirement as part of this project. The detached garage would be required to have a downspouts and gutters attaching to a dry well in the rear yard, most likely in the center of the rear yard in this case. But that would be a standard requirement due to the size of the garage and driveway being installed.
Okay. I have no other comments.
Oh, yeah, okay, very good. All right, thank you. Any other questions for staff, petitioner? Actually, I have a couple things I just want to point out for clarification to staff. In the staff report, where it mentions the fire department about the fire alarm system, the residential fire sprinkler, carbon monoxide detector, that these are all requirements that fall under the all other codes and ordinances of the Village of Skokie shall be fully and strictly complied with.
Correct. Due
Okay.
to the size of the addition, the sprinkler and alarm requirements are now required.
Right.
Carbon monoxide detectors would be required during any remodeling.
Okay, so, right, those are non-negotiable items?
Correct.
Right,
Okay.
I'll
Along-
state them for the record anyway.
Yeah, that's great. And then also too, and we noticed this comment from forestry in 2 of the prior cases about the tree protection will be required for all trees on site or in the adjacent parkway. Again, that falls under the all other codes and ordinances of the village will be strictly and fully complied with.
Right. One thing I'll also point out is the house is vacant and has been vacant for quite a while. So, and as the petitioner stated, although it isn't apparent from the outside, is in a state of disrepair. So the completion of this project, the second floor, bringing things into repair, you know, I think will certainly have a positive impact on the surrounding area.
Yeah, awesome, great.
Did anybody else want to testify?
I was just going to say that. Hi, good evening. Good evening. You'd like to say something in regards to this case?
Yes.
Okay, please come on up to the podium. And please tell us your name and spell it so we may have it for the record. sir.
Very easy. John Reed, John, Reed, R-E-E-D. My
Okay.
wife, Rosemary Reed.
Okay.
We're the owners of 9450 Keystone, the property to the south.
Okay, so the property just adjacent right
Correct.
next door?
I-
Okay.
What I would like to interject, first of all, I think for ourselves, it's nice that that building, that home is going to be taken and something done to it. It has sat for many years. It has been unlocked. There's been many different residents, many different owners.
Waters in there.
We've had people in there. We've had a rat problem with rat problems with the building. And it is uninhabitable. And really that if, with mold and being uninhabited for the many years, just to say that you're putting in a second addition on it, I think is ad-libbing a little bit over. You're really gonna have to gut the building and get it down to the foundation. And really because of the way it has been treated over the years. From the plan, as you can see, it looks like that it is a square foundation, but if you look at it in the southeast corner, the southwest corner is actually just a patio, so there is no foundation there. So if you're gonna build a square, you're gonna have to dig a foundation anyway, in order to go up. So you're building on a pedestal. Now with the history of the lot, 1955, when 54 when it was built, you had Foster Avenue, and that was positioned back to the city. With our property with 4.5 feet, the driveway has a bigger variance to the house to the north than it does with us. The driveway has more room. Now, if you're going up to a second floor, you're looking directly into our home, which is a privacy issue. That's just on the foundation piece, and it is an error, so it was allowed to get built on error at a 4.5 instead of a 5.5 when the house was originally built. I know there is cost going in there. They're gonna be trampling on there's no way they're not gonna be in our property while the construction is on through fencing. At 4.5 feet, where's the fence gonna go? In order to work on that property, it's gonna impact our property in order to trees and digging up. There is a tree that's shown on this property that's gonna have to dug, so there is gonna be impact on our home during this construction at that 4.5 feet variance. Just in terms of physicality of that space. Now, when you get into the roof, there is water issues in the whole neighborhood. There was an alleyway in the back that was pitched, the yards are pitched back towards the alleyway on the west side of the building. I have video showing that whenever you have any substantial rain with an inch in the current, we flood. So all of the water runs from all the other properties into our area. We're not in a position, we're working to get that solved. You know, we can do the best we can, but you're looking at a huge investment. To pump water into the backyard, the dry well will help, but any other residual water, especially in this gutter that runs to the back, if that's not handled, it's gonna run, it runs into our yard. I have video, if you wanna show you the video of that flooding. I have to put a pump out there every time it rains to a hose. All of the other neighbors, once again, pump all the water onto the street. So any water abatement for the property needs to go towards the street, not to the backyards, because we already have a flooding problem back there. We want the building gone. We want it torn down. We want the neighborhood to come up, but really it's just to say it's adding on a second roof, there is some other issues that it's not within variance. It wasn't built within variance originally, and now it's a variance again. I think that's something the city really should do. And if you look at how much lot is on the north side of the building versus ours, I don't think that's fair in the neighborhood, or especially on our property or any future property owner that's in there.
May I say something as well?
Yeah, please, you're Mrs. Reed, I take it?
Yes, Rosemary.
Okay.
Like Rosemary, Reed,
Okay.
Reed.
Okay.
Several of the houses that you mentioned on our block, we're really thrilled to have neighbors come in. Because for a long time, we'd see people going in and out of there prior to it being bought that were squatters with plastic on. It was pretty bad there for a while. So we're really thrilled to have someone come in, take this property and do something with it. But those homes that you mentioned across the street that did go 2 stories up, I don't know if you guys know about this, but they've also had flooding in their basement after they've gone up, because there's so much water coming down that I know that even though you have all this drainage that you're trying to put in, the water still needs to go somewhere. Our basement personally has flooded several times because our houses are very close, and when they're basically what happened was the water was going directly into our basement when it wasn't draining properly out of their home. So we've had our basement flooded several times, and we do everything to protect it. So that every time there is, and he's saying substantial rain, but we're not even talking substantial. We're talking about like, you know, an inch or 2 of rain. We're out there with sump pumps trying to get it out, trying to keep it from coming up. And that's half of our backyard becomes like a lake. By now we call it Lake Okeechobee. It's our little joke. We've had ducks come and like, because there's that much water. So it's something that I know that you guys will make the right decision. We trust that you're gonna do the right thing. That's why we live here. And we want them to come in. We want this house to be lived in. We want them to make it to do what you need to do so that you can live there properly. But be conscientious that every time we change that variance and you are getting closer and you're going bigger and we are adding things to our backyards that don't allow for, I mean, the rains just keep getting worse. And I know that we keep trying to do things to keep up with it. So please be very conscientious to what you say yes to today, because, I mean, the impacts, we say yes now, and you build these 2-story homes, and then your basement will be flooded, and I'm sure somebody wishes someone would have said, hey, you know, let's just make sure that we do everything so it doesn't flood.
Yeah. And once again, it's what we said, we don't like the property the way it is. Our neighbors don't like the way the property is, and it needs to be taken care of. But in the future, for the benefit of the neighborhood and the village, I think that with the amount of property that is there available to this 1.5 foot, if you're gonna have to do that, I think it's a reasonable request. You know, especially if you look at the plans on the foundation on that southwest corner, it's really a slab. It's not really a foundation. You're gonna have to dig anyway if you're gonna support 2 stories on that corner. Because right now it's a 4x4 beam, and a screened porch. So it's really, there's nothing there. You're gonna have to build onto something.
Okay, so I just wanted to, and thank you very much, because really appreciate the testimony. So I'm going to go through and sort of address a couple points that you mentioned. So let's start with the building foundation. So, and I guess we can talk about these, you know, code violations that maybe occurred. So I'm going to ask Brian to elaborate, but basically I think, you know, you'll explain when these kinds of projects are approved, it's not just building the 2nd floor. Everything has to be according to code. Would that be correct?
Well, what I believe would be the southwest corner of the existing building it's roofed over. There's a column, a post in the back corner. Technically, by zoning code, it is covered and it's counted as part of the building because it's roofed over. So it is counted as part of the footprint of the existing building. If there's modifications where they have to add, they have to pour and add a little bit of foundation in that southwest corner, they're gonna have to do it. If they if they're ripping out the existing foundation of the house and repouring the entire foundation, that would be considered new construction.
Right.
Where they're gonna, if the existing foundation remains and they have to add on in the back corner of it, and portions of the existing walls remain, technically it is an addition, it's not a new construction. It may, most likely this building will look like a new house when it's done. There's no question the proposal shows that a complete gut interior rehab of the building. But if they take out the existing foundation, it's now considered a new home, that's a different case. If they keep the existing foundation and they have to add in the back corner, because that small southwest corner is covered, technically it is considered part of the building footprint right now. So if they were to continue that existing footprint up, it's still considered an addition, because unless they start removing the existing foundation.
And I'm talking about something really more globally to bring up what your concern was. So if, for example, the plans are submitted, is civil engineering looking at this to determine if the foundation is sufficient to support a second floor?
Civil engineering would review their existing and proposed grading plans and a topographic plan to verify that they're not going to be draining, and downspout gutter plan, and also with the driveway and the garage to see where their stormwater is going. Our plan reviewer, who's a licensed architect, Nathan Kriska, will be reviewing the plans in regards to the building code requirements, the existing foundation, what's being shown on site as existing, and how they're building this addition and remodeling the first floor and basement.
That's what I want to make sure was covered, was, your thing is that there is, somebody's looking at that.
Yes.
And then the civil engineering is actually looking at the flooding, and so they'll make requirements.
Civil engineering will have to review this project in relation to grading and in relation to stormwater. Where's the stormwater from the existing house going to the front, to the back? Where's it going? How is it being discharged? And also for the proposed driveway and garage.
Now, let me ask this question just in general. So if I have a house of X number of square feet footprint, is there an effect on flooding or water flow, whether it's 1-story, 2-story, or 3 stories?
It depends on, well, it depends on where the water's being drained from the buildings and the grading of the property. If the downspouts and gutters are properly, if the downspouts and gutters are, if you can do underground and do pop-ups 15 feet away from the front yard, 15 feet from the house, and as long as you have proper grading, you should be able to control the stormwater on site.
So this may end up being less of a problem for you potentially, based on what you're saying, than you have right now.
Depending on the grading, it should get better. As part of the project, they will have to submit a grading plan to verify that they're not going to be negatively impacting not only the south neighbor, but the neighbor behind them to the west and the neighbor to the north.
Right.
I have a question.
I just say one of the things, and I'm sorry, I just wanted to mention this, is that when the plans are approved, as they're built, they're inspected, and if they deviate, they have to be fixed.
Yeah, our civil engineer will be required to do a final inspection, will be required to do inspections on the driveway, the dry well, unless they can get all that stormwater out to the front, and then a final grading and final stormwater inspection.
Okay.
To see where the downspouts are being discharged to, pop-ups, grading, et cetera.
Alan?
Yeah.
I have a question for you, Brian. In general, they're saying that whole neighborhood is flooding. Is the village doing anything to address that problem?
If the owners contact the engineering department, they can give the owners some proposals and some ideas as to what can be done. Sometimes in areas where alleys have been vacated, if neighbors get together, there's projects that can be done that they will do regrading, get a drain out in the back and run it out in someone's side yard and out to the front yard. But typically, they'd like to do that for multiple properties, so something can be designed to help multiple properties and not, it can be done individually. Individually, you can invest the money and do your own work. Part of it in some areas is the soil type. There's a lot of clay in some areas. I've been to some sites where I met a gentleman who was digging out his backyard and basically excavating down 6 to 8 inches and regrading and getting rid of the soil he felt was terrible clay soil and nothing would drain. So there's things individually or as a group that can be done if they contact our civil engineering division.
Has the sewers been replaced in that particular area? I know we were doing
that I'm not sure.
I'll comment. It does flood. The street does flood, but in a heavy rain, because all of the all of the drains or all of the downflows are onto lawns, and lawns run onto the street, and then it floods on the street. Then within 6 to 8 hours, it drains. It's very heavy in front of the house, the property, 90 or 50.
So you understand, though, that our flood control project promotes street flooding so it doesn't overwhelm the sewer system.
Correct, yeah, we're fully aware of that, but in the case of our houses on both sides where the alley has been removed, because of the way the alley was originally constructed from the houses down, it wasn't graded, so a lot of that water, when they graded up to close and to fill it in, the water runs into, so it's crowning and all the water runs into the backyards. So we're in the lowest part of the street. So all properties around it tend to run into our yard. My neighbor had to spend out of pocket $1,700 just to get a gravity feed from his backyard to the front, and it all goes to the front. So it's an investment for the homeowner. It's anywhere from, we would need to pump it because we can't get gravity. We can't force the water uphill because our lawn is in the back, is lower than it is. So we have to invest in raising our property or building French drain with electric pump to pump it to thumb, which is just anywhere from $3,000 to $5,000 investment. So there is a cost to it. We've dealt with it. Some pump in a bucket and it goes out to the hose out to the street, and we run it to the street. But it is a problem and they have the same problem. But now if you look, you're adding a garage, yeah, you've got a driveway. Where's the water from the driveway go? And you cut in, it's gonna, if it's not graded correctly, it ends up in our yard.
I think it was you said paver?
No, civil engineering commented that due to the Foster Street vacation, the north part of the lot, it's incorrect. On the plate of survey, it's noted as a vacated alley. Technically, I believe it's the vacated portion of Foster Street.
Yeah.
There are restrictions. One of our planners gave me a copy of the ordinance. There are restrictions on building in that area. There's a utility and drainage easement in that area, so you cannot construct a building in that portion of the vacated Foster Street. Civil engineering would only allow in regards to, fences are allowed because a fence can always be removed and it's not obstructing drainage. Civil engineering would only allow a driveway in that portion of Foster if it was a permeable paver and had proper drainage in that portion of the vacated Foster Street. That way, water could properly drain and would not be running off to the neighbor's property.
Not only that, but pavers could almost be considered a temporary structure as opposed to concrete, which is a slab and pretty permanent as well.
And also impermeable.
And impermeable.
Yeah, and most of the neighbors have that. We were south of that, so we don't, but properties near there have the paver stones.
Okay, I think
especially
the designer wanted to offer some
Yeah.
testimony here. You can
Mr.
stay up
Zurl,
here
yeah.
if you'd like.
Go. Yeah, you have something else you'd like to add, Mr. Zurl?
Yes, I think part of the problem currently is that, as it is with the building as it stands, the downspouts are actually kind of just discharging right to the foot of both houses at the moment. So, from our previous conversations with Mr. Bryan, he had let us know that actually that the best idea would be to discharge towards the front of the lot. In fact, at the moment, we do have a bit of a gradient going in that direction, and if that's the direction from Civil, that they want us to direct all the water out of that area in between the both houses, then that's gonna go straight into the street as
So that's why I think
mentioned.
between that and the.
That's less of an issue. It's an issue currently because the shape of the roof, the gutters are disrepair, and any water that comes off runs into it. It's a narrow and it's dry. There's no sun in there, so there's no grass or anything. It's just hard packed clay.
Yeah.
So it runs, that pitches towards the street, which is not an issue. When we had, 15 years ago, we had 3 inches in 1 hour, way back then. Yeah, we got water in the basement, but there's still flooding there, especially now you're going higher up, the pitch of the roof. At that height, basic engineering, it's gonna flood on, if it's that close, if it's running off at a high rate, it's just going, keep coming over to our side of the street. And if there's no water abatement over there, we have to deal with that in that 4.5-inch area that it's dry.
Well, it should be all gutters, right?
There's
Around.
gutters, but right now the gutters are.
Right, no,
shut.
but I mean, it should be all new gutters.
And then the front of the house, yes, it runs, and the back, we run ours into our own lawn, but, because that's, we do the same thing. We have
Right.
downspouts into the yard.
Right, well, the water's a very serious consideration, and I know you guys take it very seriously.
I mean, I
at the
can show you,
village.
I have a video, if you want to see the video, how much, when we had just this week on the 1st, how much water we get in the backyard.
I believe it. I mean, we've dealt with numerous flooding issues to this board before, and no, we take it under serious consideration. I'm sure all of us have had, that are a village resident, have had water issues before, so it's not something we take lightly, believe me.
And going back to the initial part of the variance, and I do think, if you look at the building, I think that when you get into it, and you start looking at the structure of the building, it's really not adding a second floor. There is some age and abatement, so you are gonna have to do a pretty big rehab on that building. There is mold issues in the basement on the foundation, so that's gonna have to be looked at, because I've gone down there when it was empty, and it's molded and flooded. It was down there. I don't know how long you've owned the property. But prior to that, if the previous owner, the previous people who owned it have been cleaning it up, but prior to that, there was mold and issues and down there. I know there was some cleanup, but whether that just was a surface clean or it solved the problem of the mold and the flooding. It's a 1954 foundation.
So, Brian, let's ask us, again, and you can just, remind us of this. The plans are approved, but somebody actually goes and looks at the property and says, hey, before you build the second story, you have to make sure you solve the code problem.
As part of the permit submittal, yes, they will have to have plans submitted by a licensed architect for the addition remodeling work that's to be done. In regards, if they're showing an entire new foundation along the south side yard, it would not be approved as presented because it's been presented as a second floor addition, not a new single-family home. If they have to do minor work in the back corner to add or shore up some existing foundation or add a little piece in the corner, that would be different than building an entire new south wall foundation.
Right, but what about mold, for example?
It's part of the permit process there during the remodeling. We're going to be inspecting first floor, basement, second floor.
Okay,
yes.
that's what I wanted to clarify for the record.
I believe Commissioner Shaw had a question for the petitioner.
Yes, I have a question for the owner. Is any particular reason he's moving from Martin Grove to Skokie?
My mom, she's coming from Pakistan, the one I'm backcountry, and she's been planning, and my sister, they have been planning to move over here after 6-8 months. So I'm getting the new house to making the bigger one.
So you're planning to move, you're not the investor, right?
No, it's not about the investment.
Okay. So you're not buying the house, rehabbing it, and flipping it, in other words?
No.
Okay,
no,
for
no.
personal use. Okay, great. Thank you. Yes, ma'am. I was just going to ask if anybody else wanted to speak in the matter of this case. Yeah, if something you please do, ma'am. Absolutely. Just tell us your name and spell it, and so we may have it for the record, and what your relationship is to this case.
Good evening. My name is Rosemary Tate, T like Thomas, A, T like Thomas, E.
All right?
And I am here on behalf of my neighbor, Tom Carson. He is out of town, but he wrote a letter and he wanted me to read it into the record tonight. Is that acceptable to you?
Corporation Counsel?
That's fine.
That's acceptable. Where's your neighbor live?
He is at 9444 Keystone Avenue,
Okay,
so he's just 2 houses away from the property.
okay.
And he wrote, November 18, 2018, "We will be in California starting today until the 16th of December and cannot attend the village zoning meeting on December 5, 2018. My wife Judith and I strongly object to the proposed remodeling of the house at 9456 Keystone Avenue. The house has been a blight on our neighborhood for many years. The house was neglected and full of mold, rats, and left to squatters. No one who knew the full history of the house would want to buy it or live in it. A remodeled version of it. It should be completely torn down and the foundation replaced. Thomas Carson, 9444 Keystone Avenue. P.S. We demand that the previous owners of this house compensate the neighbors for introducing rats into our neighborhood and pay for a professional exterminator to do a thorough removal of all rats in the neighborhood. Dr. Carson." That's it.
Well, Corporation Counsel, I don't know how much weight that would have about somebody who is an owner of a property having to pay for rodent removal for a whole neighborhood.
Yeah, we don't really have power for that.
Yeah, I don't think so. Yeah,
If they would just do it for that house, I think he'd be fine with it.
yeah, right.
Do you want me to take the letter for?
That
Yeah,
would be
to the
fine,
record.
yeah, so that Marlene can put it into the,
There you go.
yeah, please do. Did you
We're
want
gonna
to
have some more
direct it to Mrs.
testimony
Tate
here.
here?
Yes, Mrs.
Yeah,
Tate?
Mrs. Tate?
Scratchy notes.
Commissioner
I don't-
Gerstner has a question for you, Mrs. Tate.
Yes.
I just want to let you know that, one, we can't require a petitioner to tear down a property that they purchased. Two, what they're proposing is just as good as tearing it down, because they're taking it down to the studs, to the walls. That's going to be gutted, and when they move in, that is going to be a new house. It's technically a remodel for zoning purposes and building, but that's going to be a new house, and it's going to look very nice in the neighborhood. So any objections that this doctor has right now, when the house is finished, and in looking at the plans, you're going to have a beautiful home in that area. And they're going to regrade. We're going to make sure that the water doesn't flood the other places. The neighbors, the dry wells going in. So it's going to be much better off than it's been, past 15 years? So I can say that it's going to look 100% better than it's looked in the past 10 to 15 years. So, and you'll finally have somebody on the block that's actually living there and not squatting.
So, okay.
Thank you.
No,
We have some
you're
more
very
testimony.
welcome. Yeah, okay.
And I'd just like to
Yep.
state, I've been,
Just for your record, just state your name.
oh,
again.
this is
You
Carlos
don't-
Sorella.
Yeah.
Thank you. I'd just like to state, I've been in the house many times, and I have never seen any indication of any animals living in the house. I've never seen any rats being there. I've spent multiple hours in the basement and the first floor and all around the area, but I've never seen any vermin that are currently living in that house.
Okay.
John Reed, I'll comment on the vermin. They were living in a shed that was between my house and the south side prior to you purchasing it, And once that was torn down, there was nowhere for those rats to go but into every other household. So if you want to come in my garage and see the rat traps that I have in my yard and the rats my son sees in the evening, that's another story, and we'll film them for you if you want to see it. So there are rats in the neighborhood. Now, that's a different story. This is not a question about rodents. But in terms of what you said about tearing it down, studs, and being a new house and being part of the neighborhood, I think the commission should really think that it should be equal upon all neighborhoods. If other houses who went through the same process had to meet the same variance of the 6 feet, I think you need to consider for consistency of the neighborhood, why should one home suffer from the other just because someone else made a mistake when they built the house in 1955 at 4.5 feet? Because that's a consideration for the entire neighborhood, because at one day they want to sell and I want to sell, they're going to say, what am I going to, that house is way too close because it's going to deplete my value of my home because it's too close to theirs. And that's something that I think the board needs to consider, is that overall value of the homes and those conditions in the neighborhood, and it should be consistent. And if you look at the lot line, there is plenty, 1.5 feet, foot and a half either way. It's one wall or another going either direction, and I think that is a reasonable request, that you change the variance, for not accept the variance, and you maintain that 6-foot variance. Thank you.
I have a
So,
question for you.
Commissioner Salovey.
What would your suggestion be about this? Continue this case, an investigation?
I would look at, I'd like to see the plans and make sure that that foundation is correct. And if there does need to be work on that foundation for a second floor, and it requires work on the foundation, I think you need to really adjust and make the variance back to 6 feet for the 1.5 feet. You're gonna have to dig anyway. And you're looking at one wall. What's the footprint, 40 feet? And can you move to the other side? It's 1.5 feet. Square footage, you got plenty of room to go up. Can you go left and right? No, they haven't considered going forward or backwards. They've kept it where it is. Why can't you go back or north, east or west or north on the building?
Well, that would actually require the same exemption, because it's just the existing building that's grandfathered.
But you don't need a variance to go east or west. You don't.
If they were to keep the same width of the house, they would be required to also obtain a variation, because they still would not be providing the 6-foot side yard. If they were to keep the existing width and go straight back or straight forward, they would still need a variation. So this is keeping the same footprint but going up, not increasing, coming further out or further back.
And I think, and if you're looking at it as a if it's not a business investment and it's a long-term investment, the additional cost of the foundation for the value of the property long-term is well worth the investment at the end. Because if you look at the homes and the values of homes, 300, an average price in that neighborhood is 300,000. There's other houses across the street that have gone up in the same footprint, are looking at 6 figures listed. So there is some economic gain by making the house and doing the second floor. So in the long run, yeah, you're paying it now, but there is an investment. You're going to get some gain at the end in the value of the house as it grows.
Well, not only that, but I think if you see an improvement in that house as opposed to what exists now, in the long run, you're going to benefit from better water drainage, and all the property values around your neighborhood are going to increase as a result as well.
And if you were in a single-family home and you had this that close to you looking in your property, is that a comfortable situation? No, maybe you're going to have to keep your blinds closed on that side of the house. That is an issue. You're that close to it, and I think for myself or other future owners of the homes, it's the same thing. For us looking to them and them looking at us, and it's 1.5 feet. It's not like we're asking you to move it to the other, 10 feet the other way.
When you purchased the home, was it already that close?
Yes, because if you read the report that was built, the variance was at 4.5 feet, and it was a single-family home, and there was no fence or anything. The previous owner, the original owner, actually had moved, because it was 4.5 foot, didn't like it and built the fence on our property to get the foot back. So we had to go back and get a replot to show them to get our variance back because it was too close for them. Thank you.
Yeah, you're welcome, Mr. Reed. Thank you very much
Yeah.
for your voicing your concerns.
I can't tell somebody that buys a house that you got to tear down your house and you got to move it 2.5 feet. That's not fair. It's absolutely not fair. What if I came to you and said, you know what, your house is too close to there. I want you to move out, tear it down, and move it 4 feet. You'd say I'm nuts. So they bought this house in good faith, and I'm not going to tell them they got to tear the whole house down and move it 2.5 feet to the other side. So,
in my opinion, if I was going to go and take it and I knew the house had to be rebuilt and I'm making an investment, it would be my civil obligation to meet the codes. And if the code says 6 feet, I would have to do what I need, or I wouldn't consider the property, because my civil duty is to meet the codes or ask for a variance. And
he's meeting the codes.
Because it's already existing?
That's correct.
But is it really if it's really a tear down, or is
It's not a tear down.
But
It's a remodel.
You're describing as a tear down, so I think we need to
It's a
clarify
remodel.
that.
It's a remodel. If they tore it down and they tore the foundation out, as Brian said, then it's new construction, then it's a different story.
But even if you modify the foundation, it's not new construction?
Brian?
Well, we're talking, if a licensed architect comes in and submits plans and shows an entire new foundation wall along the south side of the house, this is considered it would be considered a new house with new walls.
Right.
If they're showing, a licensed architect is gonna stamp the plans and say the existing foundation, and they may have to do a minor modification in the back corner in a small minuscule area, but the existing foundation stay, portions of the existing first floor walls are staying, it technically is considered and has been considered an addition.
Right.
That they're tearing out if this gets approved as proposed, and in 6 months, 3 months, they come in with plans and it shows an entire new foundation with a 4.4 foot setback, staff will deny the plans because this is now considered a new single-family home. Everything that's been presented has been for a second floor addition with interior, first floor gut rehab, and we know in that case, portions of the walls are going to have to be rebuilt, and the house was built with a permit, albeit it looks like in the wrong location from the research I've done. There was an old site plan from whatever year was 54 that I cited, that clearly showed 5.5 foot setback on the south side. What exactly happened 60 years ago, I could not tell you, whether it got spotted out wrong or someone let them build it closer to the lot line. I do not know that. If they were to come in for a permit today to rebuild portions of the first floor wall and to remodel portions of the first floor, we would allow them to do it by right because there was a permit on file. This building was clearly built with a permit. We would allow them to do that and rebuild portions of the first floor wall and remodel the first floor existing. The second floor is now a different story. There's no second floor there. If a new foundation comes in and all new walls are going in, it's now a different story.
Right. So you understand that, Mr. Reed, right? So in other words, what staff is saying is if this foundation is substandard and it's a new foundation, then it has to go to existing code, which is the 6 foot minimum.
Then I would like to ask that be a condition of that if it doesn't.
Yeah,
It's already a condition.
It's already covered by the last sentence in the motion, that all other codes and ordinances of the Village of Skokie shall be fully and complete and strictly complied with. So if they come in with the site plan and the foundation is found lacking, then it has to go back to 6 foot, and what we're discussing tonight is null and void.
Okay.
And so just to clarify again, and I know this is for my benefit as well as for yours, Mr. Reed, that either the building department, the engineer, whoever looks at this, is going to make a determination, an independent determination, whether the existing foundation, maybe with minor repair to the southwest corner, maybe not, is sufficient. In other words, somebody's going to look at that.
Correct. We have a plan review who is a licensed architect who's been on staff for at least 30 years, who will be looking at that. If there's minor modifications to the existing foundation, it'd have to be done. that's not uncommon. If this is an entire new foundation, this is now clearly considered a new single-family home.
And the staff will determine if that's necessary.
Correct.
Okay, that's the key, and I think that's what you're asking.
Yeah, I just want to make sure that's a condition and it's going there, because like I said, I don't think that really shows the true nature of the home.
Yeah, no, we understand, Mr. Reed. Well, we want to make sure that when they build this thing, it's not going to fall over onto your property.
Yeah, and like I said, we've all said, we want families in the neighborhood. It's a great area.
Yeah,
We don't want that building set. It's a great school district. We just want to make sure that things are done right, and then we're concerned about the neighborhood, that it's done correctly. So,
Yeah.
we're happy that they're moving and doing something with the home. We
Yeah.
just want to make sure that it's right and make it fair on equality in the neighborhood, because other homes are all in line with those variances of the 6 feet.
Yeah, absolutely, sir.
Thank you.
Okay, you're very welcome. Anybody else would like to say anything in regards to this? I think that's it. Anything else anybody would like to add? No?
Make a motion.
Yeah, then if not, the chair will entertain a motion.
So I'd like to make a motion to grant a variance. Mr. Chairman, I propose the following in the granting of a variance to the petitioner as follows. That petitioner's name, and Adnan Memon is the owner of the lot described in case number 2018-16Z. For the property located at 9456 Keystone Avenue, Skokie, Cook County, Illinois, and that said lot is a plotted lot of record and is abutted by single-family dwellings on the north and the south, that a determination has been made in which the petitioner's request is consistent with the majority of the findings of fact as stated in the Village of Skokie's zoning chapter. I therefore propose a variance be granted with conditions which I'll state to the petitioner for forgiving failure to comply with the requirements of the zoning ordinance of Skokie as amended, and specifically, this is section 118-111 parentheses 6A for failure to meet the sufficient side yard requirement, specifically 4.44 feet versus the required 6 feet in an R1 single-family district, and that petitioner be granted the variance with the following conditions. So first of all, we noted that if the driveway is going to be built with the garage, which isn't a part of this, that there will be a dry well, and in accordance with civil engineering's requirements, that in accordance with the fire department's requirements, there's a fire alarm system, residential fire sprinkler, outside weatherproof horn strobe mounted near the front door, which activates on water flow only, and carbon monoxide detectors. That during construction, tree protection is required for all trees on site or in the adjacent parkway. And that all other requirements of the Skokie Village Code be complied with. That's the motion.
Okay. All right, very good. I have a motion. The conditions actually that you pointed out are covered by the all other codes and ordinances of the Village of Skokie shall be fully and strictly complied with.
They are.
Which is something that I asked staff about earlier, because that forestry thing was alluded to in a couple of our prior cases, and I wanted to make sure that was indeed part of that. So that's it, yeah. Okay, we're all good. We have a motion to approve. Do I hear a second?
Second.
All right, Commissioner Jacobson seconds. The chair will go ahead and call the roll then. Commissioner Salovey?
Yes, but I'd like to compliment the citizens for coming here and letting us know about the problems in your area. You should be complimented for that.
Okay. Commissioner Arden?
Yes.
Commissioner Jacobson?
Aye.
Commissioner Gersner?
Aye.
Commissioner Shah?
Yes.
Commissioner Beverly?
Yes.
Commissioner Perlin?
Yes.
And the chair will vote aye. So in the case of 2018-16Z, 9456 Keystone, the request for variation has been approved unanimously. Corporation Counsel, what does the petitioner need to know from here on out?
For the last time, we will prepare a covenant running with the land. Should be ready in about 2 to 3 weeks.
All right, thank you very much.
Good luck with your project.
Yeah, but, yeah, Mr. Reed, though, yeah, I understand the flooding issue. I would ask that you and perhaps some of your neighbors contact the village staff and see how, what best that your neighborhood could do as a group to help ameliorate some of that flooding issues that you do have. So, yeah, I mean, our staff is excellent.
Yeah, they would contact civil engineering on the second floor. And
Right.
ideally, if it is a group effort, it seems to work out a little bit better because cost is split up. But they would help with some grading to show what the existing grading, what a proposed grade has to look like to help with that.
Yeah.
But civil engineering would be the department to contact.
Okay. Yeah, nobody should have to deal with undue flooding in their neighborhood, so.
Thank you.
Okay, all right. All right, hope we helped you out.
Thank you.
All right, you're welcome. Okay, well, that's it. All right, our next meeting will...
Won't be till next year.
Yeah, it won't be until next year, so happy holidays to everybody. Yeah, and
Because no cases were continued, we will not meet on December 19th, and we
Right.
will not meet on January 2nd.
Okay, so in other words, our next meeting would potentially be January 16th?
Correct.
Okay, so, well, we got a little time off to enjoy the holidays then, I guess, huh? Anything else? Pardon me?
Which will be
Yeah, next year, right. And just in closing, too, I'm sure we've all noticed that we have a new member on the board tonight, Jessica Beverly, so I'd like to welcome Jessica, and that, yes, and that's because Cindy Franklin has moved to the Plan Commission to replace the retiring Mort Paradise, who's given many years of service to this village, so please congratulate Cindy when you see her, and please welcome Jessica to the board. Okay. All right, if that's it, then this meeting of Village of Skokie Zoning Board of Appeals is adjourned. Happy holidays and Happy New Year to everybody.